Hello everyone, this is Tom Fox and welcome to episode 17 of the FCPA Compliance and Ethics Report. For those of you who don't know me, I'm the author of Lessons Learned on Compliance and Ethics, Best Practices under the FCPA and UK Bribery Act, GSK in China, a game changer for compliance, and also the editor of the FCPA Compliance and Ethics blog. Today I would like to visit with you about 5 trends that I've seen over the past 18 months, which I think are going to impact FCPA and generally anti-corruption and anti-bribery enforcement on a global basis going forward in 2014. So I'd like to visit with you today about these and ask you to consider how they might impact your compliance program going forward. The first one is transaction monitoring. And we first heard about substantive transaction monitoring from the Department of Justice's declination to prosecute Morgan Stanley back in April of 2012. And we've had a couple of other instances in enforcement actions going forward where the DOJ suggested that transaction monitoring is an appropriate tool to use in your compliance program. In the Eli Lilly SEC enforcement action of December of 2012, there were 2 situations of the 4 bribery schemes that Lilly was using around the globe, which I think lend themselves to transaction monitoring. The first one was Lilly's use of the distributor model in Brazil, wherein they gave one distributor a discount which was outside the standard range for distributors in Brazil, and the distributor used that additional discount to not only increase his sales, but to pay bribes to feed that increase of sales. The second one was Lilly's scheme in Poland, which was to pay charitable donations, or make charitable donations rather, to a non-medical service or non-pharmaceutical charitable foundation called the Chudau Foundation. The Chudau Foundation was run by the Director General of the Silesian Health Service. Lilly had a spike in sales in Silesia, which led it to become the highest grossing province in the country of Silesia for Lilly. I think these 2 situations, or 2 schemes rather, used by Lilly point to the need and usefulness of transaction monitoring so that a company could see if a sales spike occurred either with a specific sales representative, such as the distributor in Brazil, or in a sales territory, such as the province of Silesia in Poland. If there's a sales spike, I certainly hope that a company would engage in analysis to determine the reasons for the sales spike. But now we have the situation where it may be appropriate to also analyze it from the compliance perspective and to tie that sales spike to any violations of any internal anti-bribery or anti-corruption programs that the company has in place. So, number 1, transaction monitoring. Number 2, international corruption and bribery enforcement. I think the GSK in China matter will be a truly game changer for compliance. The reason I think so, this is the first time we've had a foreign country enforce its own domestic anti-bribery and anti-corruption laws against a Western company or a foreign company for bribery inside of that country. So here we have the situation where China is prosecuting GSK and now investigating a wide host of other Western companies for conduct of bribery and corruption in China. So we have the overlay of 3 laws. We have the People's Republic of China official and commercial bribery law. We have the US FCPA, and of course GSK being a London-based company, we have the UK Bribery Act. This is really the first time we have seen this going forward, and it wouldn't surprise me for other countries to draw from China's experience and begin to prosecute foreign countries for bribery inside of their borders. One thing the GSK bribery case has made clear is that you need to look at the termination of employees and the employee relationship. If there's an unhappy exit and there's anything askance going on, that employee may now be incentivized to report to the Department of Justice or the Securities and Exchange Commission under the the Dodd-Frank whistleblower program. So we have, or in China, we had a disgruntled Chinese employee who left the company reported to various Chinese authorities. And so we have this situation going forward, so you need to manage that very carefully. But I think overall the lesson to be learned is you need to take a very close look at your policies, processes, and procedures in China and move forward to other countries in Asia to make sure you're not being perhaps put in the limelight for an international anti-bribery and anti-corruption effort going forward. Number 3, if you've ever heard me speak, you know that my FCPA mantra is document, document, document. And I'd like to use the J.P. Morgan hiring program called Sons and Daughters as an example of why documentation is so important. For those of you not familiar with this matter, J.P. Morgan is alleged to have hired sons and daughters of high Chinese governmental officials or officials in state-owned enterprises. They were targeted with specific business benefits in mind from their family members, so that we have sons and daughters targeted to be hired and thereafter a contract be awarded to J.P. Morgan. This, unfortunately for J.P. Morgan, was all set out in a spreadsheet. But the Sons and Daughters program started not only innocently enough, but actually appropriately enough, because it identified sons and daughters of Chinese governmental officials so that the company could give extra scrutiny to them because of potential FCPA liability. And somehow this program was not properly monitored, and it morphed to a program where instead of transparency and visibility, that it was used directly to target the hiring of sons and daughters of Chinese governmental officials. They were fast-tracked to be hired by Morgan. Fewer job interviews were required. There were relaxed hiring standards. There were subpar academic records, and there was lacking, these sons and daughters lacked relevant business experience. And as I said, unfortunately for Morgan, they have apparently a spreadsheet which ties the specific hiring of family members to the specific targeting of their parents for contracts. So that's about as damning as you can get. Hiring of a family member under the FCPA is not prohibited. In fact, there are 3 opinion releases approving this specific conduct. So this can be done under the FCPA, but the key is to document it. The key is to document all of the relevant background, experience, educational records of the prospective hire. And then you need to try to ring fence that son or daughter away from any contracts which their parents may be considering to award to your company. So once again, the hiring of sons and daughters is not prohibited under the FCPA, but it can raise red flags. And I would like to actually read a list of questions that Mike Volkov came up with, which I think are excellent for you to pose in this area. So if you'll forgive me for reading. Number 1, who, if anyone, at the company is sponsoring or supporting the applicant? Number 2, how did this applicant come to the company's attention? Number 3, what is the applicant's relationship to the foreign governmental official in question? Number 4, what involvement, if any, has the foreign official had with the company relating to the applicant's interest? Number 5, in which office or division does a foreign governmental official serve? Number 6, how important is the specific office or division to the company's relationship with the foreign government? Number 7, is the applicant qualified for the position that he or she has applied for? Number 8, has the applicant or will the applicant be subject to the normal hiring process? Number 9, has the company completed a due diligence review of the applicant and the foreign official to identify corruption risks? Number 10, has the company or any representative provided assistance or assurance to the foreign official or to the applicant that the applicant will be hired? So the lesson I would ask you to draw from the J.P. Morgan hiring scandal is that even if red flags are raised in a particular business transaction, or in this case, hiring transaction, they can be overcome if you put a well thought out program in place and document that program. So that's why I continue to preach the 3 most important things in an FCPA compliance program are document, document, document. Number 4, risk management is more than simply risk assessment. I think it's pretty well understood and pretty well known that risk assessments are a key tool in any compliance program. Indeed, the U.S. Sentencing Guidelines says that companies must conduct periodic assessments of risk of criminal conduct and to take appropriate steps to design, implement, or modify each element to reduce risk. The OECD says risk assessments are the basis for an effective compliance program and internal controls. And the UK Ministry of Justice's 6 principles of an adequate procedure compliance program says that broad categories of risk must be carefully examined. Program priorities, resources, controls should be determined based on the results of the risk assessment. So a risk assessment is a key tool, but you actually need to utilize that risk assessment in moving forward. So what are some of the risk factors that your company may face? Well, there's the country risk, which is a correlation between growth markets and corruption risks, and of course the TI perceived level of corruption. Sector risk: has the government publicly stated the industry is under scrutiny or already conducting investigations in that sector? Are there corruption risks particular to that industry? Business opportunity risks. This is one item that I don't think receives as much attention as it should, because if you have a very high value project, that's probably because there's a high risk involved. Whether that risk is financial risk, construction risk, delay risk, or corruption risk. But if there's a high value project, you may need to take a little bit closer look at that. If you have multiple contractors or intermediaries. What about your business partnership risk? What are the government relationships? Are you relying on third parties? And transactional risk. I talked a little bit about charitable donations, but also political contributions. And then what licenses or permits, and how many? How many different agencies are you going to be required to get? So the key, though, is to use this risk assessment and use that to plan out the management of your risks going forward. A strong preventative measure if done before something goes wrong. Do not simply have a wait-and-see approach. Use the risk assessment, use it to plan, use it as a tool going forward. You should build a risk assessment into your overall risk management program. I've emphasized that you should utilize this as a starting point, but I also advocate that you should conduct a risk assessment annually, using around the same time of the year with a consistent group, such as internal audit, enterprise risk management team, legal and compliance. They need to understand the array of risks that you face and undertake a comprehensive review. This risk assessment can be used as part of your scrutiny of new business partners and third-party agents, whether they be in the sales chain or in the supply chain. A formal risk assessment provides an opportunity to take a closer look at recently established business relationships and proactively address and remediate any problems which may arise. It also gives you the ability to update policies and procedures based upon enforcement trends. So if we take a look back at GSK in China, this should give you the opportunity and insight to do a risk assessment of your Chinese operations. It's important that you memorialize your risk assessment findings in a reporting process. Here again, we see the tie into document, and then that you would tie in your actions going forward based upon this risk assessment. And the last thing is individual enforcement actions in 2013. Prior to the GSK matter, Mike Volkov had said it is clear that FCPA enforcement for 2013 will go down as the year of criminal prosecutions of individuals. And I have to agree with Mike on that. While the GSK matter may have greater implications for wider or broader anti-corruption enforcement on a global basis, I think it's clear that the Department of Justice is taking a very hard look at prosecution of individuals under the FCPA. The first thing to note is that the Department of Justice continues to use all of criminal law enforcement techniques available to it. No matter what you may thought of the gun sting and how it ended, the department is using undercover agents. They're using cooperating witnesses. They're using wiretaps. Every tool available to them in the white-collar enforcement world, they're using in FCPA cases. Clearly, the Department of Justice is signaling that if you cooperate, you'll be given credit for that, and I'll speak to that in a moment. And the use of other statutes and other charges continues to be part of the arsenal or tool bag the department uses going forward. So back in the spring, we had 4 individuals from the Tulsa company BizJet. The president and CEO Bernard Kowalski, the Vice President of Sales and Marketing, Peter Dubois, Vice President of Finance, Neil Ull, and the Regional Sales Manager, Jald Jensen. Both Mr. Jensen and Mr. Kowalski are not U.S. citizens and have not been formally arrested nor extradited to the U.S. Nevertheless, Mr. Dubois and Mr. Ull have pled guilty. And here the great significance is that these gentlemen both cooperated and they received substantive and substantial credit for their cooperation. Peter Dubois was looking at up to 10 years in jail, and he received 8 months home incarceration at 60 months probation. Neil Ull was looking at 5 years in jail, and he received 5 years probation. We've had 4 individuals from Alstom arrested this year. There's been no guilty pleas as yet, so we don't know what the sentencing would be. We had a representative of the Israeli company BSRG, Frederick Sillens, who was arrested, and this case in many ways is the most fascinating, but it also shows the wide scope of tools available to the department. The department had a cooperating witness who was the alleged bribe receiver. Mr. Sillens is alleged to have attempted to purchase back from this alleged bribe receiver the alleged contracts which specified the amount of the payments of the bribe, and so that a second bribe was offered. After this offer was made, Mr. Sillens was arrested. The cooperating witness was wearing a wiretap, had provided copies of the contract to the FBI and the Department of Justice. So once again, showing the undercover nature of investigative work under the FCPA. Mr. Sillens is scheduled for trial in December. He has pled not guilty. So we'll have to see how that works out. We continue to have fallout from the 2008 Siemens settlement. And here we had a former directive, Uriel Sharif, agree to settle with the Securities and Exchange Commission for securities law violation. He paid a $275,000 civil fine, which is the second highest penalty assessed against an individual, and agreed not to be a part of any U.S. publicly listed company's management team going forward. In the continuing fallout from the Wilbros case, Paul Novak pled guilty to 1 count of conspiracy and was sentenced to serve 15 months in federal prison. This summer we had 4 individuals involved in a case with a financial brokerage firm in the United States called Direct Access Partners. 3 of the individuals were employees or directors or brokers of Direct Access Partners, and a 4th was the person who was alleged to have received the bribes, who was an official at the state-owned Venezuelan bank Bandes, who alleged to receive bribes, and for receipt of these bribes, she generated more than alleged to have generated more than $66 million on trades for Direct Access Partners. The interesting thing about the Bandes official is she was not charged with a substantive FCPA violation as a bribe receiver, but with money laundering, but also was arrested and arraigned in Miami. So they were able to get jurisdiction over her and bring her to the United States. So those are some of the trends I've seen. I have the materials that I have related to you available on PowerPoint or a white paper on them. So if you would like either one of those, please email me at tfox@tfoxlaw.com. If you have any questions, I'm happy to answer them as well. And that concludes this episode of the FCPA Compliance and Ethics Report. Thanks for tuning in.